Justice A.K. Sikri is a former judge of the Supreme Court of India, and he currently serves as an international judge at the Singapore International Commercial Court. With decades of experience across constitutional, commercial, and arbitration law, he has authored thousands of judgments, and he continues to shape the legal landscape through arbitration, mediation, and global judicial work. Let's dive straight in. Hello everyone. We're about to begin a specially curated fireside conversation with Honorable Justice A.K. Sikri on the evolving role of the judiciary, about law, about life, philosophy. So tune in and enjoy it. Welcome, Justice Sikri. It is a pleasure to have you with us today.
Thank you very much.
I'll dive deep inside the aspect of how law changes for a person as they move from advocacy to judiciary. And is there any fundamental difference you see when you make that change? Or is there any fundamental knick-knack that you see specifically with the law as you make that change from advocacy to judiciary?
Okay, I think in order to answer your question, let me, because I've seen there are many students who came to meet me before this function started. Yeah, and so let me start with this. What is our position as a lawyer? And when you are transitioned as a judge thereafter. I remember when I completed my law, my LLB. Of course, I should not say that, but the context forces me to say that. I was topper in law, who had topped in all 6 terms, and I was a gold medalist. But the day I joined law, my father was also an advocate, senior advocate. Mr. Basin knows his office and my father's office were next to each other. They were
Nice.
close to each other in the same building. So I have my association with Mr. Basin the day I joined law. But in the morning, first day, when I was going to attend the court, he gave me a book, autobiography of Mr. Talwar. And he said that must read this, but let me show you one thing from this book. He took out that page where I still remember the words of Mr. Talwar, which he had written there, that and it was, I think, meant for me only, as my father gave it to me. And when I read that quote, it said that, look, you may be a bright student in law, you may be a gold medalist, these are the words used, but don't join this profession unless you can't work hard in the profession. So as a student, you may have done well, but profession demands totally something else. And that is the hard work. And if you can't do the hard work, don't be in this profession. So this is, I think, he wanted to burst my ego, my father, that look, don't think that if you are a topper, that you will do better in law also. It's a new innings you are starting, and you start the inning from the scratch, and that can be only by sheer hard work, your integrity, and the way you perform in the court. Within a few years thereafter, in because, again, that's a message for the students and young lawyers. One lawyer, a senior lawyer, he's still in the bar. So he said in one of the functions that, look, it's not the number of years you put in the profession which makes you a good lawyer. It's the number of hours and minutes in those years which you put in profession that will make you good lawyer. A person may be in the profession for 10 years, 15 years, 20 years, but he or she has not put in that work. On those days, he just whiled away the time and did not do the work, hard work. Then a person who has put in only 5 years or 7 years, but given more time, more minutes, and more hours, may be better than the person who has put in 10 or 15 years. So, this is what I say is the lesson. And coupled with that, when you argue the case as a lawyer, yes, uh, whatever is your case, you have to defend or you have to put forth the case of your, client. You sometimes, these are the weak cases which come to you. You have still to do your best. Sometimes you know that I may not succeed. Still, you have to put your best foot forward. But in the process, as I said, you do your best as a lawyer, and then we leave it to the judge, we leave it to the court as to what they are going to decide. While doing so, hard work, as I said, but apart from that, this is integrity of the process and the way you argue matters a lot. And in this way, because sometimes there are some lawyers who have the tendency to try to uh, project the this facts in a way or to distort those facts, which should not be, because sooner or later judges also come to know about the goodwill of a lawyer, and that reflects a lot ultimately, because I have seen the judges, a lawyer who is arguing and making a statement, they will treat it as a gospel truth, going by the reputation of that lawyer that he is the person who is not going to say anything contrary to what is on record. And there are others, when they say something, the judge would look into the papers and try to satisfy himself or herself whether what is he saying is correct or not. But these things pay ultimately. Anyway, so coming to your question, that ultimately it is the duty of a lawyer to do it, his case, argue it to the best, and then see. As a judge, the role changes altogether. There are two lawyers who are arguing the case before you, and now you have to find who is right, who is wrong, what is truth. I mean, there may be there are always disputed question of facts also. It's not only law, but the people are projecting, both sides are projecting different facts. So as I remember, Justice Midha uh, of Justice Delhi High Court said once, on his retirement, and that still echoes in my mind. And he said that, look, the two advocates or the two parties who are arguing and who are before the judge, they know what is the truth and what they are projecting. It is the judge who is on trial, because he has to find the truth. So that
Right.
is what the function of a judge would be, if I may say so. And so therefore, it is judge who is on trial. We have to, our instinct have to, but let me tell you from my experience, as I have seen, uh, over a period of time, a conscientious judge who really wants to do his work with honesty and with purpose and commitment to justice, we develop sixth sense. We are able to know where the truth lies. Of course, it is not always easy, and there are sometimes, as we call, easy cases, hard cases. And easy cases are those where, I mean, from the start of the case, even when you have read the file, you know what is going to be the outcome of this case. And as I said, that lawyers also sometimes argue, but they know what is going to be the outcome. But hard cases are those where the uh, both the outcomes are possible, but at the same time you have to do justice, and which particular outcome you should choose, that becomes really challenging task for the judge, if I may say so, to come in answer to your question, that this is how I will.
Yes, and how I see it now with your answer is that there is a commonality here where the lawyers, both of them, they know the truth as well, but the judge has the choice to decide what truth is the actual truth. And there are various versions of it, of course, but of course, from a legal lens, they have to decide. So that commonality is there that both people know the truth eventually from a legal perspective. Uh, you also mentioned that hard work is something that everybody needs to do in the profession, especially as they get into the litigation space or any other space for that matter. Do you think the definition of hard work, Justice Sikri, has changed over time? with the advent of technology. I'll give you a small example, something like a quick draft on AI. There's a lot of hesitation actually in the judicial space against AI now. I don't know why that is. Maybe it is to do with the hallucinating judgments that we are seeing. But do you think the definition of hard work has changed because of that? Quick stuff coming out through all these chat GPTs, Claude Pro, all of that. And drafting is easier now. So, what is your take on that?
Definition of hard work has changed in the sense that you have now technical tools to help you. In our time, suppose when we used to do research, there were no computers. I joined the profession in 1977, and we used to have digest, Supreme Court digest or some other digest, and where we'll try to find the case law, and or you will go into the judgment directly. I mean, each year's journal you will pick up physical
Yes.
copies of the journal from the index, and on a particular proposition you want to find a judgment, so you'll spend hours together in order to find those judgments. So digests were little better in the sense that yeah, on one particular topic you'll find which are the judgments which have already come, those citations will be there, but then again you will go back to pick up that particular book and see whether that judgment and read that judgment to see whether that helps you or not.
Right.
But in that sense, yes, technology has helped. Now you have on computer at the click of your button, you can on one particular say SCC online, you go and all the judgments on that particular point, they are there, not 1 or 200 or 200 or 500 judgments on a particular point. Sometimes now the challenge is to find out which is the most appropriate judgment
Relevant.
for you out of those 500 judgments. But so in that sense, and then you rightly say, when it comes to drafting or even finding the law, AI is, is still step forward vis-a-vis the computers. But at the same time, and there's a lot of debate going on in last few years about this, that whether on the one hand it is going to really take away the work of the lawyers, but if I may say so, in nutshell, technology is there in the form of computerization or whether it is AI. One can take help to start with, but law is one subject where you cannot copy paste,
Right.
because ultimately when it comes to even the drafting of pleading also, it would depend upon the facts of that particular case. And as it is said, although we cite the judgment many times as precedent, but judges have always said, and everybody believes, lawyers have also said, jurists have said, the two cases are not identical, always on facts. So, and we also know one particular fact of a case may change the decision also, that they may look very, very similar, but one fact which may be different may change the outcome of the case. So therefore, depending upon, as you rightly mentioned, AI it's an artificial. It's not put in the its brain or its mind to the peculiar facts of that particular case.
Correct.
You may have fed in, but then as far as this AI is concerned, there is already a material stored there on the basis of which it would bring out the results and will give it to you. So that may be a starting point, but then one must apply his or her mind in making the drafting or even preparing the case for arguments. Without that, and particularly when you have given the example of hallucination also, sometimes you get a judgment which would, a particular case which never was delivered. There was no judgment.
Yes.
And that is the hallucination of AI only which has produced that result. Because if you see how much information is fed, and when creating or this thing, particularly output for your particular problem which you have given, and the AI has, or the technology has gone into all those material which it has, and sometimes they commit mistake. So therefore, uh, yeah, hard work has a different definition, different connotation. But insofar as doing hard work is concerned, that uh, essential attribute still remains insofar as you have to be a successful lawyer. Because that you can't wish away. And those who think that we will just go to AI, either draft the plaint or a petition, or on that basis we'll argue on that basis, they are not going to be successful ultimately unless they put in their own, which is not artificial, but it is real brain also, or intelligence also.
Yes, and you mentioned that we used to go over digests and used to jot down judgments and citations. I remember a very super senior person within my family used to tell me, keep a diary and write down judgments every day with citations and write down uska kya subject matter hai, so that you have like an entire copy of things that you're reading on a daily basis. Do you think that's still relevant today? Uska koi fayda hai? What is the?
Yeah.
It is still
You
relevant.
see, even you go to Chat GPT. Now there are so many,
Yeah.
and you go to that in legal field also. There are so many now which have come out, and same problem you give it to those, they may come out with different results.
Yeah, yeah.
So therefore, which is correct, unless and you apply your mind and verify that.
Yes.
So don't copy paste and then think that in 2 minutes I have done this work, which would have taken 2 days earlier in our times. Maybe with computers, when they came, maybe it would have taken 10 hours, and now it is taking 5 minutes or 10, 20 minutes. But then that is not a shortcut, way of doing the things, which in law particularly, it can't help.
So no shortcuts in the law, definitely. And now coming to the fact that you yourself, sir, have authored over 4,700 judgments, if I'm correct. That's the right number. You continue to contribute to the arbitration space, the commercial space. Globally also, you're a sitting judge, as international judge of the Singapore Commercial Court. Any judicial philosophy singularly that you follow, or there are multiple variables to it?
This is an interesting question. You see, I tell you, if I may say so, and even when we joined the profession in those days, and now also many talk about it, although it has reduced that kind of discussion, that when the judges, there are, Mr. Basin knows, we used to practice in labor law a lot. So we had in those times Justice Krishnaya, Justice Reddy Chinnappa Reddy, and Justice Desai. So we know if the case has come before them, it is going to be pro-labor. And
Pro-labor.
Pro-labor.
Okay.
So, and likewise, if it is dispute between tenant and landlord, it is approach is going to be pro-tenant. So, therefore, there used to be this kind of discussion that this judge is pro-labor, this judge is pro-tenant, this judge is pro-government. There are judges who will not decide against the government. They will try to take out, try to find a method to decide somehow, or not to get. Or there are judges who will always decide against the government. That is also because they think that no, not because of any that they are against the government, but they think that, okay, a matter has come where this is an individual who is fighting the government. It can be in any capacity. He may be an employee. He may be, he may have got a contract from the government, which contract terminated, and or he may have done some work and he has to recover money from the government, or it may be some law which is challenged, or it may be some executive order which is challenged, against which that individual is coming, or some company is coming. And then the philosophy of some of the judges, no, those who come, particularly, if the government has done something, it must be that government would have done wrong to him. So it is our duty to rectify that.
So it is more of a philosophy or a bias, you would say?
But having said that, but it is not that normally judges would have a particular philosophy or something. Some judges have, but I don't think that that is proper or that is legal. Ultimately, the function of a judge is to decide according to law, number one. And when I say according to law, that doesn't mean that what I mean is that, look, you can't bring an outcome which is completely contrary to law. The law says something else, but no, you want to give relief or you deny relief, and therefore you do that. So that is not judging. That is not rendering justice. So that is one thing. Second is, as I said, that look, we have to ultimately do justice. So where justice lies in, I told you, in easy cases, and from my experience, I know if you have judges doing 100 cases, 90 to 95% cases would fall in that category of easy cases. That case comes, the facts of that case or the law which is to be applied is very clear, and which way it is to be decided may not. I'm not saying it may be very hotly contested case, but from the judge's point of view, the resolution of that dispute may not pose much challenge as far as judge is concerned.
Right.
But when those 7 to 10% cases which are hard cases, and those hard cases means that where you struggle, where the justice lies in this particular case, and what kind of outcome I should bring about. I would say the judge's philosophy should be, which I have. That was a question. Yeah? That to balance between the two competing claims or the rights, and then to find out where fairness lies. You, as Mahatma Gandhi had also said somewhere, and which I remember had read, I don't remember the exact words which he uttered, that you just close your eyes and see that, and try to find out, if I decide the case in favor of X, then what are going to be the repercussions of that? How much benefit, if X is entitled to, but then what is going to be the prejudice to the to Y on the other side, and vice versa,
Right.
and then come to a conclusion. Many times, I tell you frankly, while, and this is my experience while writing the judgment, you are and after hearing the arguments also, you are at fix that what should be done. So what I would do, let me start writing the judgment. I'll start dictating the judgment, call my steno, start dictating these are the facts, these are the arguments, etc. And sometime when you are in the midst of that, when you are reproducing or dictating what are the various arguments and the judgment which are cited, all of a sudden something clicks. Oh, this is the best way to decide.
Yes, that happens with a
Yeah.
lot of other things.
And sometimes that doesn't happen. So I'll stop there. Ask my steno to go, and I'll see, let me think over it. After next day, I'll again start dictating. But ultimately, you are, as I said, that you develop that sixth sense. And if you really, your focus is, and your aim is to do justice in the matter, and with objectivity, you want to do, and uh, 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 so therefore, ultimately, you will be able to arrive at some solution which is just and proper. There are, in this process, I may say, see, as judges of the Supreme Court, even High Court, we are wedded to Constitution. Of course, Constitution applies in the case of a district judge also. But when I say High Court and Supreme Court, because constitutional issues, constitutional matters come. And so therefore, ultimately, we have to see, when we, what is the what are the ethos of our Constitution? What it demands? What is the role of the judge in a constitutional democracy? That becomes very, very important. And as I always said, and have written a lot on that, I think I've reflected in judgments also, but otherwise in my articles and essays, that their true primary role of a constitutional judge in a constitutional democracy. And these are, number one, to uphold the rule of law. So it is very, very important to uphold the rule of law and the Constitution. So therefore, the constitutional ethos and the principles, constitutional principles, have to be kept in mind. And number two, which is more important in our context, is that to bridge the gap between the law and the society. This is what I'm not saying that it's my own. It's borrowed from Justice Barak, Aaron Barak, who was the president or chief justice of Supreme Court of Israel, and he has written a very, wonderful book on that, the role of a judge in a democracy, where he has highlighted two these two roles, which I've kept in mind, and in the Indian context, and keeping in view the Indian philosophy of law and ethos of the Constitution, when I say, then when now you are talking about many social issues come, and so there it is now. We were talking about the pro-labor or pro-tenant judges. Then we have another category of judges, activist judges, those who are, I mean, believe in activism, judicial activism, and there are those judges who will go simply by the letter of law and finish the matter.
Yes.
But when it comes to the those matters where you have to do social justice, then you have to be activist. My definition of activism is different, because uh, there are three wings of the state. There's a parliament, or I will say legislature, because at state level it's not parliament, state legislature. So there's legislature, there's executive, and there's judiciary. We have in our constitution also what we call the separation of powers. So therefore, there's one criticism of the judicial activism is sometimes you start doing the work which is meant for the executive or even the legislature. You have there are many judgments. It is, I mean, which amount to legislation also, that the court has said that this should be the law till the time parliament enacts the law. So there has been a criticism of that, but I would say, if you and I agree with that. So we have to be within our confines. At the same time, not that where judicial activism is necessary within our scope, without transgressing the lines, judicial activism is necessary to advance social justice. We must do that. And I give you one very interesting example. Actually, as I did, and there are many, many cases from 19 here, I would laud. I gave those examples of Justice Krishna, Justice Chinnappa Reddy, and Justice Desai, who have done wonderfully well. And this invention or bringing the PIL in Indian context, public interest litigation, again is a big contribution of Indian judiciary in doing social justice. Here, when I say like the rights of the scheduled castes and scheduled tribes, rights of those who are oppressed, rights of women, and rights of disabled persons, etc. Hey, you can, and you see, if I give you two examples, very interesting example, and that will, um, uh, I mean, what I want to convey, I think would be conveyed in a better way. This sexual harassment at workplace, Vishaka judgment.
Right.
And our transgender judgment, which I had given me and Justice Radhakrishnan, and that Nalsa case. Now, in both the cases, the Supreme Court in Vishaka, there was no law at that time that how to deal with the sexual harassment of women at workplace. But then, drawing from CEDA, that convention, international convention, to which India is a party or signatory, although no law are under our constitution, even if we Indian government has signed some international treaty, that doesn't become a law automatically till the time law is enacted. Correct. So although India was signatory to CEDA, but there was no law enacted on that. But still, the Supreme Court said, going by this, that this is one thing, sexual harassment at workplaces, this has to be curbed, and this is necessary, and this is in a way, upholding the dignity of women in the country. So apart from laying down that law or conferring that right on women, they even at that time they said that till the time Parliament legislates, this should be the law which should be applied by everyone.
Right.
So it amounts to legislation. In transgender, we did the same thing. While recognizing the rights of transgender, we said there is no law till the time law comes. This should be the guidelines which should be followed. Now, these two judgments were always lauded. There are many judgments which are decided by the Supreme Court and where they have intruded into the field of the executive or the government field or the legislative field, where there have been a lot of criticism, and rightly so, as I said, because we have to be confine ourselves within our limits. But when it comes to these two judgments, even nobody in the government, also in the legislature, also nobody criticized these judgments, and ultimately law were brought by the legislature also. Unfortunately, there's one amendment which has taken place, which is Transgender Act. I don't want to comment much on that. Let us see what happens. But what I was saying was that role of a judge when it comes to doing social justice, that likewise disability, where I started in Jijabai Ghosh, etc., that dignity of these persons who are suffering from disability, then inclusiveness of theirs in the society, that which is very, very important. Now, and it's a matter of human rights for them, or fundamental rights of the persons who are disabled. And it's not that we have to just see them with pity. It's no more medical issue any longer, that we give full attention how to treat them medically, etc., and take care of them. Sorry, that is not the that is good, but that's not the only purpose. If you really want that they should be given their dignity, then you have to empower them. You have to ensure that they are given proper education, and they are able to overcome the obstacles which they are having because of physical or other kind of disability, and they become essential, or rather more useful part of the society like any other human being. That is what human right is. That is what their dignity is.
So equality amongst equals. It is safe to say that
Correct.
when we're deciding social justice judgments, or when the judges are transgressing lines, in so as to speak respectfully, between the various pillars, the Article 15 plays a very important role. Are you saying that? Is it safe to say that, sir?
Yeah,
Yeah.
Article 15 obviously Article 14 is which talks generally about equality, and 15 and 16 are that talk about the equality in specific sense. Where if you have seen it, 16 is about employment, 15 is about on as it says that even about women, etc. It's there's specific provision made for all this. So therefore, how you interpret the fundamental right is there, but in action, how the judgment interprets. So
Right.
therefore, there the I would say the philosophy of a judge to do justice in such cases, and particularly when it comes to human rights. I just now see Mrs. Jaitley is here. We had discussion. I remember Mr. Arun Jaitley once talking to me when I was sitting judge, and the two examples which I have given, I had him in mind. He said about that, because there had always been a debate whether judges, when they are, over activist, etc. He says no problem. I'm sorry. He said that look, when a particular policy is made by the government, and law is very clear that judges don't have right to say policy is right or wrong. If it is yes, falls, is against some particular constitutional provision or some statutory provision, you can always set it aside and say that, but not that you substitute your judgment, because that's the domain of the executive or the government to come out with policy. But I remember his words saying that, look, when it comes to human rights, judicial activism, the legislature or the executive has never condemned. And that is
Right.
why I gave those two cases, example
Right.
of those two cases.
Right. And you also spoke, sir, just now about separation of powers. I want to quickly dig into one question there. When we're looking at the evolution of the judiciary over a period of time, we're looking at the collegium, we're looking at appointments, and there's a lot of conversation about that. A lot of people have criticized it, a lot of people have said that's the only way out. What is your take on that?
Take on what?
The collegium appointments.
Also, you're talking about Collegium.
Just generally, what do you
No,
think should be the way?
it's a, again, a topic of very, very hot discussion. I would say two things on that. Uh, you see, there are different kinds of systems or different kinds of procedures in different countries in choosing their judges. And there are in some countries even elections for choosing judges.
Right.
So it depends upon the ecosystem, the social conditions, social background, etc., of that particular country, that how you choose. Insofar as if you see it from a constitutional perspective or legal point of view, there was one, mechanism which was provided in the constitution, how the judges are to be appointed. And no doubt, the collegium system which is introduced is contrary to that. There can't be, any two views on that. At the same time, maybe in 1994, when this judgment 94, 93 judges case 1, 2, 3, that all these judgments came, they thought that there were some uh, infirmities or some weaknesses of the system, the way it was prevailing. So therefore, let us have more inclusive by having collegium, not only the chief justice recommending and the government, as they say, government is appointing, let it be like this. By having maybe on papers, what was thought that it may be a better system, if I may say so, on papers. The way it has been acted upon in last few years, it has not yielded very good results. I'm very frank.
So
There
are
are
you
many
saying?
many
Sorry.
weaknesses of the collegium system. On papers, it may be one of the best system. I tell you, when as a many times many judges from different countries would come and would meet me when I was in Supreme Court. They would always be when they would see how the judges are appointed in India. So there would be two extreme reactions. One, when comparing with their own country, they will say, "Oh, this is far better," or they will say, "How judges can appoint judges?
Correct.
How you can this power can be given to judges to appoint themselves?" So therefore, those two extreme views may be there, but success lies, even if this method was adopted, that it should have been implemented in a more objective manner, which has not happened.
Okay. So you think that the structural change should be from all pillars? I mean, the executive and the
You see,
judiciary,
what
or
I feel is, you see, NJAC judgment, which was given, I think court missed the opportunity. It was that law which was passed, the constitutional amendment. You are striking down the constitutional amendment also on the ground that it is in the teeth of independence of judiciary. It is contrary to and independence of judiciary is one of the basic features of the constitution, as decided in Keshwan and the Bharti case. I don't think that you can say that it is impinging upon the independence of judiciary. How selection of judges, in that sense, which is always in most of the countries, would impeach the independence of judiciary? That means from before 1994, when that system was prevailing, there was no independence of judiciary. So this, at least personally speaking, I don't subscribe to that. So therefore, I think what should have been at that time, uphold the constitutional validity. At the time, the act which was passed, where the executive uh, took with itself more control, you could have said that, look, yeah, change these provisions. These provisions may be impinging the independence of judiciary. So give more powers or equal say to the judiciary also in the appointment, so that there is a balance maintained. So they could have upheld the constitutional validity, at the same time strike down some of the provisions of the act to bring it in conformity with the concept of independence or doctrine of independence of judiciary. That could have been, I feel, more balanced approach.
thank you so much, Justice A.K, for being so candid. I would have liked more time with you. It's been a spontaneous and a very interesting conversation, but we're short on time. So, one quick advice to young lawyers that you'd like to give, and we would like to
I
wrap
think I
it up.
started with that. First thing, work hard, work with commitment, and with integrity. I tell you one thing. Today, in our time when we joined the profession, and any person who will join the senior will not even give any money. So many times for many months, or they will start with maybe in those times 500 rupees, 1000 rupees, 2000 rupees, etc. So nowadays, I've seen many of them when they join, they will ask the senior how much you are going to pay me. Of course, I'm not saying that it's wrong to ask for money, but money should not be the consideration in the beginning. Your concentration should be that how I am able to prove myself in the profession with my hard work, how I am able to establish myself. So integrity is more important. And I would only say that in order to get the work also, which would be good for the society or the judicial system as well, try to do some social work, in the sense legal aid work. And again, another thing which you should, and which is what the ecosystem where we are going, and today judiciary is overburdened as far as caseload is concerned. I mean, it has crossed 50 million, which is really mind boggling. 54 million now. So, and it is increasing post COVID. It was at around COVID, it was around 30 million. So 30 million to 54 million in 6-7 years. It's really mind boggling, and it's becoming dangerous. It is assuming dangerous proportions. So therefore, mediation is one way how to avoid litigation, and so that the cases don't come to court, and how to ease the burden of the court. So therefore, start doing this mediation, see about it, and become a mediator from the beginning, even when you are in college, because now it has bar council has made it compulsory subject. So therefore, do these things. I mean, some social service, some, and ultimately, this is one profession, I tell you, where you can earn money, tons of money, by legitimate means. So don't think of making easy money. I have seen many lawyers may have made much money, but those who have become great lawyers, they were all honest and hardworking. So that is what it should be.
Thank you so much, Justice A.K. It was a pleasure. Thank you.